Well, good morning, everyone. I'm Barbara Beckert with Disability Rights Wisconsin. We're so glad to have you all here today for Guardianship in Voting, Preserving and Restoring the Right to Vote. I'm going to make a few opening remarks, but I first want to make sure that we're fully accessible. I see our interpreter is here. Michelle, do you need us to give you the capability to multi-pin? Yes.
I think that's all I need to do. Well, I'll spell you out.
All right. We will just take care of that. Okay. I think you should be all set. All right. So if we can bring up the PowerPoint, please, Jeannie. Great, thank you. Next slide. So again, thank you for joining us today. We're excited to have such a great turnout for a very important topic. Our training today is sponsored by Disability Rights Wisconsin in partnership with the Board for People with Developmental Disabilities and Wisconsin Disability Vote Coalition. Next slide. We have a great group of co-sponsors, so thank you to them. I'll read them quickly. SIL Western Wisconsin, Employment Resources Incorporated, Greater Wisconsin Agency on Aging Resources, League of Women Voters of Wisconsin, Love Inc., Milwaukee County Aging and Disability Services, My Choice Wisconsin, People First Wisconsin, Survival Coalition of Wisconsin Disability Organizations, the ARC Wisconsin, Wisconsin Coalition of Independent Living Centers, Wisconsin Guardianship Association, and Wisconsin Guardianship Support Center. Thank you all for your support. Few words about Disability Rights Wisconsin. We're the federally mandated protection and advocacy system, and part of our charge is to help protect the voting rights of people with disabilities as required by the Help America Vote Act. If folks have voting questions, including about voting and guardianship, we hope you'll contact the DRW Voter Hotline. We're available all year round at 844-347-8683. We also coordinate the Wisconsin Disability Vote Coalition with our partners at BPDD. A lot of great information on voting. Check us out at disabilityvote.org. Next. So a few logistics that we appreciate your help with before we begin our training. First, we ask you to please remain muted. This will limit background noise. We do want to hear from you though, so use the chat feature to type your questions. We have an ASL interpreter. If you need help accessing the interpreter, put your request in the chat. Auto captioning is provided. We want to make sure our meeting is accessible. If you need auto captioning, you can use the CC live transcript button in your menu bar. Speakers, please say your name before you speak. That helps with accessibility for people who are low vision. And finally, watch for a follow-up email with links to the presentation and resources. Our lead speaker today, Ellen Henningsen, has put together some wonderful resources, and we want to make sure you have access to those. Next slide. And now I will turn that over to our lead speaker. Please take it away, Ellen, and thanks for all your hard work.
Thanks a lot, Barbara. My name is Ellen Henningsen, and as Barbara mentioned, I'm going to be the main speaker today. I'm going to be speaking to you today about guardianship law and its impact on voting rights. Some years ago, I worked in the area of guardianship law. I was one of the leaders who helped pass what's our current guardianship law. And if some of you were around back then, you may remember me from doing statewide education on what the new law was all about. I've done other things since then, and I am now directing a project at Disability Rights Wisconsin called the Voting Rights and Guardianship Project. I've been a volunteer guardian myself, and I am also a poll worker for the City of Madison. Next slide. My talk today is going to contain a lot of information. Don't worry about remembering it all. Disability Rights Wisconsin is publishing 2 resource guides, and I'm showing you the first page of one of them called Guardianship and Voting, How to Get Your Right to Vote Back, a summary. It's a quick reference guide, 4 pages, written in plain language, helpful to individuals under guardianship who lost the right to vote and want to get it back. Also, it'll be helpful to everyone else. My talk today may not be in plain language, but so use the guides as a resource. This is the second guide. It's much more detailed, very step by step. It's 19 pages, so obviously longer than the other one. This guide includes the legal forms and instructions that you'll need to use the court process. Both of these guides will be available on various websites, and as Barbara mentioned, we will be emailing you the links after today's program. I'm going to be talking about a variety of topics. And again, remember the resources, because the resources go through all this again. At the end of the talk, there'll be plenty of time for your questions. I'll put them in the chat. We have a panel of experts who you'll be meeting later to answer your questions. I want to start with the basics so we're all on the same page, so we're all going into this topic with the same understanding. The basics of voter eligibility and the basics of guardianship law. We'll be looking at how to keep your right to vote in the initial guardianship process, also how to get your right to vote back if it was lost, and how to convince the court that you should get your right to vote back. As I mentioned, you may be generating questions, and there'll be time at the end for that. To get us started on this topic, let's watch a video. It's an interview of Barbara and a young woman, Jennifer, who has a guardian and who lost her right to vote when a guardian was appointed, and then she got it back. You'll hear both Barbara and Jennifer mention some key concepts that I'll be talking about. So we're going to watch a 2-minute segment now, then I'll do some more talking, and then we'll watch some more later. So let's hear from Jennifer. I think we're having technical difficulties.
It looks like the sound is off still.
Yeah, okay, so let's start back again. Excellent.
You are watching How I Got My Right to Vote Back, a video message from Jennifer Kratsch, voter and self-advocate from Disability Rights Wisconsin.
Hi, I'm Jennifer Kratsch. I am a self-advocate and I got my right to vote back. I'm excited to share my story with you all about how I got my right to vote back. I hope you all can have the same experience that I did.
Hi, I'm Barbara Beckert with Disability Rights Wisconsin. The right to vote is one of the most cherished rights in our democracy. In Wisconsin, people under guardianship retain the right to vote unless the judge expressly removes that right. If you have lost the right to vote, you can petition the court to have your right to vote restored. Thank you, Jen, for sharing your story of how you got your right to vote back and inspiring other people. Jen, how did you find out that you lost your right to vote?
After I had my right, after I had got guardianship, the judge said I was incompetent of voting and said that I didn't have the knowledge or the process of voting. And then after I went to the self-determination conference in 2015, I heard a lawyer tell a story about Jenny Hatch of how she lost all her rights, and that's how I wanted to get my right to vote back. So that next day, I called my guardian and asked her if I had my right to vote. But if I had my right to vote, she had to look through the guardianship papers, and she said no. And then when she asked me if I wanted to get my right to vote back, and I said yes.
So now let's talk about the basics of voter eligibility. Actually, I want to step back and talk about that video first. Note how Jen was inspired by the story of another person with a guardian who went and got her rights back. I hope she can inspire you to get your right to vote back. And I hope she can inspire others listening today to support individuals who want to get their right back. Jen is one of many people throughout the state who have gotten their right to vote back. And hopefully this talk will help others do the same. So now let's start with the basics of voter eligibility. You are eligible to vote if you are a US citizen, at least 18 years old, a resident in Wisconsin for 28 days, you are not currently serving a sentence for a felony conviction, and you have not been determined by a court to be ineligible to vote. I included the part about the felony conviction only to make sure that we had a complete list. I'm not going to be mentioning it again. Our focus is on the very last line. You have not been determined by a court to be ineligible to vote. I want to review the basics of guardianship. So again, we're all entering this presentation with the same understanding. There are two types of guardians who can be appointed. One is a guardian of the person who is authorized by a court to make specified personal decisions on behalf of the individual who under the law is called the ward. There's also a guardian of the estate who's authorized to make specified financial decisions. The court has many options. It all depends on the capacity of the individual. The court can appoint both a guardian of the person and a guardian of the estate. The court can appoint only a guardian of the person, or the court can appoint only a guardian of the estate. I have been a volunteer guardian. I was an individual's guardian of the estate. This individual was quite capable of handling her personal decisions, healthcare decisions, where she lived, when she grocery shopped, all those personal decisions we make on a daily basis, but she was unable to manage her money. And so I became her guardian of the estate, and my only authority was over her money. Now, many people assume that anybody who has a guardian has automatically lost the right to vote, and that is not true. That assumption is contrary to Wisconsin law. We often say someone has a guardian, and that's really a shorthand. We should be more careful and explain a guardian of the person and estate or estate. We know under Wisconsin law that rights are retained unless they are expressly removed. So when you're wondering if someone has the right to vote or not, we have to look at the type of guardian who was appointed. If it's a guardian of the estate only, voting rights are never, ever removed if only a guardian of the estate is appointed. Now, if it's guardian of the person, we have to learn what is the scope of that guardianship. What rights has the individual retained? What rights have they lost? These kind of rights are not transferred to the guardian. What rights have been transferred to the guardian and what rights are shared with the guardian? The answer is in the court's determination order. It's what Jen was talking about when she mentioned guardianship papers. We'll talk about those papers in a bit. But the point of all this is that under Wisconsin law, you cannot assume that a person with a guardian has lost the right to vote. So moving on to how to keep the right to vote in a guardianship proceeding. In Wisconsin, a person under guardianship keeps the right to vote. Well, I should say a person under guardianship of the person keeps the right to vote unless a court expressly removes it. If all they have is a guardian of the estate, they always keep their right to vote. Another main point is only a court can take away your right to vote. A guardian cannot, a parent cannot, another family member cannot, an election official cannot, a service provider, a teacher, or a power of attorney, even if that power of attorney is activated. Now you may be thinking, well, wait a minute, I know my family member has not lost the right to vote, but I don't think they have the capacity to be able to vote. Well, this is what the law allows. If a person can indicate who they want to vote for, with assistance or without assistance and without coercion, they should be allowed to vote. Now, in the guardianship proceeding, you should be aware that the right to vote is at risk. That's because it's one of the issues the court is considering when deciding to appoint a guardian of the person and deciding what the individual's capacities and incapacities are. The court is the one who is controlling the outcome of a guardianship case. Neither the petitioner nor the individual, who is called the proposed ward, controls the outcome. Now, you remember in Jen's video, she lost the right to vote. We don't know why. We don't have enough information on that, but we heard her say that the judge felt she wasn't competent to vote. And we'll look later at what may have led to that conclusion. So to be 100% sure that an individual does not lose their right to vote, do not file a guardianship petition. There are other options, and I put a graphic here from the Board for People with Developmental Disabilities that shows the continuum of alternative decision making. So those options should be considered. But sometimes guardianship is the best option in order to protect the health and safety of the individual. And sometimes it is appropriate that that individual lose their right to vote, but sometimes it's not. And we will talk about how that decision is made later in my talk. But if you believe the individual should keep the right to vote, the petitioner and advocates should endeavor during the guardianship proceeding to keep the right to vote. And petitioners should be careful how do they describe the abilities and disabilities of the individual so as not to jeopardize the right to vote. To minimize the risk, in filing the petition, there's a certain box that you should not check. I have there the top of the form, top of the petition, and then I have an excerpt from it that I've highlighted. You'll notice number 15. Ideally, you should not check 15A3 because then you are telling the court that you believe the individual, that is the proposed ward, should lose their right to vote. The court is relying on the judgment of a number of people, and you need to be aware that you're entering a forum where some or all of them may believe that when a person needs a guardian for any reason, they should lose their right to vote. Negative reports from the guardian ad litem, and we'll talk more about who that is later, and the doctor or psychologist can influence the court. So ideally, if you're advocating for the individual to keep their right to vote, you want to talk to the guardian ad litem you want to talk to the doctor/psychologist to convince them that they need to check the boxes correctly so that they don't argue that the person should lose their right to vote. If the individual really wants to keep the right to vote, consideration should be given to getting them their own attorney. And an easy way to do that is to tell the guardian ad litem. And we'll talk more about who the guardian ad litem is. Regardless of whether the guardian ad litem or the doctor believes the individual should not vote, advocates should be prepared to present evidence that the individual should keep their right to vote. Again, though, it's ultimately up to the court. The outcome you want is an empty checkbox on the determination and order. That's, again, what Jen was calling the guardianship papers. And ideally, you want to see paragraph 3A3 empty. Believe it or not, rights are retained or lost based on whether in certain boxes there's a check mark or not. In this case, ideally, that should be empty. Now let's switch to how to get the right to vote back. We're going to get back to listening to Jen because she is going to explain what she did to get her right to vote back. And we have to pause for a second here to figure out all the technology that goes along with screen sharing. So just a minute.
Jen, once you decided you wanted to get your right to vote back, that's a process. Who helped you to get your right to vote back?
Susan Howard is one of the advisors of the Ozaki People First chapter, and she helps me out a lot when it came to that.
Jen, can you tell us what you did to get ready for your court hearing?
I had a guardian ad litem lawyer come to Portal and ask me questions if I was ready for the court day, and I said yes I am, and I was ready to get my right to vote back so I can start voting.
What was the process like in court? What did the court ask you?
The judge asked me if I wanted my right to vote, and I answered yes. I told him I wanted to experience voting because I never experienced that before, and he said that he was happy to give me my right to vote back. And so he granted me my right to vote back, and I've been voting ever since then.
That must have been a very exciting day when you got your right to vote restored.
Yes, it was. I even made sure it was okay with the judge if I could go sit up in his chair, and he said yes I could. So that's where we got a picture taken. It was up there, me in his chair and him right next to me.
Oh, that's great that you've got a picture that captures that moment, and I've seen it before, and you look so happy, Jen. It was a big day for you and a big day for voting rights. Yeah, Jen, why is it important for you to vote?
Because I get to pick who I want to vote for instead of other people telling me who I should vote for and telling me what their opinion is on the person when it's my opinion on who I want to vote for, not theirs.
Jen, thank you so much for sharing your story about how you got your right to vote back and motivating other people to consider getting their right to vote back too. If you have lost the right to vote,
Okay. Well, congratulations to Jen. I think she was remarkably brave to return to a court that some years before had told her directly that she was incompetent to vote. And I appreciate the fact that she persevered. And I hope that you in the audience can do the same. When you are interested in getting your right to vote back, you need to determine that you, in fact, have lost your right to vote. So you need to look at those guardianship papers, the determination and order. I've already referred to that. They're back on the screen. And if the box that I'm showing is not checked, you can vote. We are aware of individuals who thought they lost the right to vote, but in fact didn't. And once they looked at their determination order, they discovered that box was not checked, and so they were able to vote. Now, I've heard that some counties are reluctant to release to guardians and to wards the determination order. Some people don't have them in their possession, so they have to go ask the register and probate. And I don't understand why they cannot be released, and we're going to deal with that in the question and answer section. But again, it's the determination order. It's not in the letters of guardianship. So if you find that that box is checked, then you cannot vote, and you want to go back to court to get your right to vote back. Now, let's chat about briefly, why would you want to go back to court when the court has already said you can't vote? Why do you want to try to change the court's decision? Well, two reasons. The first is the court might have made the wrong decision in the first place. Petitioner may have checked the box to remove the right to vote without thinking it through. The doctor or psychologist may not have understood the legal standard, and I'm going to be talking about that shortly. The guardian ad litem or the court may not have considered the issue carefully. If the person under guardianship wants to vote and believes they have the capacity to vote, Wisconsin law permits them to ask the court to re-examine the issue. And the other reason you might want to go back to court is it's possible that the court's initial decision was correct. The ward did at the time lack the capacity to vote, but time has passed and there's been additional life experience, education, and or medical treatment, and the ward may now have sufficiently matured or medically improved so that they now have the capacity to vote. In Jen's case, she was 18 when the guardianship of the person was granted. 5 years later, she went back to get her right to vote. Even if the court was right when she was 18, she now had 5 years of gained maturity, experience, and knowledge. And so that made it possible for the court to now determine that she had the capacity to vote. Don't let what happened to you in the past stop you from trying to get your right to vote back. We're going to look at several subjects now, and Jen and Barbara have touched on some of them. We're going to look at how do I start? As you've noticed from the video, you have to go back to court. You must file a petition, a legal form called a petition, and we'll be walking through that shortly. You do not need anybody's okay. You decide, just like Jen decided. She decided she wanted to go for it. She didn't need anybody's permission. You can have someone help you. You'll notice that Jen had the support of her guardian and an advisor from People First. That was very helpful, not essential, but very helpful. And hopefully some of you in the audience today can provide that kind of support to a person with a guardian who wants to get their right to vote back. You do not need an attorney. It's easier if you have an attorney. Jen did not have an attorney. She referenced a guardian ad litem, but as I've said already several times, we'll talk about who that is in a second. Your options with doing this process is you can do the whole thing on your own. You can find and pay for your attorney. You can start on your own, and then you can get an attorney. If you can't afford it, you can ask the court to find and pay for your attorney. And there's a place in the petition, which I'll show you, where you can just do that. My project is working on creating a network of pro bono attorneys, but that's not up and running yet, and hopefully it will be soon. It doesn't cost anything. You can file the petition, your guardian can file a petition, any supporter can file a petition. You file it with the court that granted the guardianship, Some of you have had your guardianship moved to a different county. If that's the case, you would file it in that county. So let's look at the petition. This is the formal legal document that must be filed if you want to go back to court to get your right to vote back. I've put two samples up, portions of two samples. You'll notice the top one is the individual's petition. That is the person who has the guardian, who we call the ward. The one on the bottom is if a supporter is filing the petition. The words are a little different, but basically they're the same. The forms and instructions for these petitions are in that longer guide that I mentioned, and we will mail you the links to where they are on the web. Here is the top portion of the petition. I want to walk through it briefly so you can see how easy it is to do. You'll see there's some blanks. Those need to be filled in. They can be filled in with a pen or on a computer. The county needs to be added, the name of the individual, the date of birth, and then there needs to be added the case number and the date of the determination and order. Those two pieces of information are on the determination and order. If you don't have that information, call the register and probate. You'll notice there's a checkbox by number 6. I'll talk about that in a second. Here's the bottom half of the form. You'll notice again, there's a checkbox in front of 2. The previous checkbox and this checkbox is what you check if you are asking the court to find and pay for your attorney. There are 2 areas for signatures, one on the left and one on the right. The right is where the individual filing the petition signs, but don't sign it yet. Follow the instructions because you need to have a witness sign it while you're signing. So it's very important to follow the instructions which are in that how-to guide. And here's a link to all the addresses of all the courts and registers in probate. Guardianship court is considered a probate court. So what happens next? I've stated there a number of steps that will happen once the petition is filed. These all happen automatically. There's nothing the petitioner has to do to have them happen. So the first thing after the petition is filed is there's a notice of hearing. The court issues that order. And I've noted in yellow that the form will state the date, the time, and the location for the hearing. And the court may also decide that it wants other people to get that notice in addition to the petitioner, usually the guardian, and there may be others. The court will also appoint a guardian ad litem. The guardian ad litem is shortened to be GAL. Even though guardian is in the name, it's not a guardian, but it is an attorney. But the guardian ad litem is not the attorney for the petitioner. Jen mentioned a guardian ad litem attorney, but that person was not acting as her attorney. That person is basically an investigator. That guardian ad litem interviews the ward and decides what the guardian ad litem thinks is the best answer to the question. It might be what Jen in this case wanted, and I think it was. I think the guardian ad litem supported her petition, but it might not be. The guardian ad litem then shares that opinion with the court. It's very important that the individual talk to the guardian ad litem about why they should get their right to vote back. Even if the guardian ad litem disagrees, the individual still can tell the court that they should get their right to vote back. It's also possible that there might be a doctor psychologist assigned to the case. It's our opinion that this is not required in this kind of case. It is required when an initial appointment is made, but the law does not require it now. But nevertheless, the court may want an opinion of a doctor psychologist, in which case one will be assigned. The individual can also have their own doctor psychologist write a letter of support. And then we get to the hearing. So there's been a petition, notice of hearing, appointment of a guardian ad litem, and possibly, but probably not, the appointment of a doctor or psychologist. So now we're at the hearing. That is the formal meeting, usually at the courthouse. That is where the individual who wants their right to vote back tells the court why they should get their right to vote back. The individual must attend the hearing, but it is possible, if you can't get to the courthouse, to have the hearing held where you live. At the hearing, the court will listen to you, the supporters, and the guardian ad litem. And finally, the court will issue a decision. We're hoping that it's favorable to you. And if it is, we provide in the how-to guides a form that the court can use, stating its order that you get your right to vote back. The court will also issue another form. It's not in the how-to guide, called a notice of voting eligibility, and that is sent on to the elections clerk. Be sure to get a copy of both of those orders. And if you vote in person, you may want to bring copies of those with you in case there's some issue of whether the voting log is correct or not. So now finally, we're getting to the topic of how you convince the court to give you your right to vote back. And this is also applicable to trying to keep your right to vote in an original guardianship proceeding. I'm going to talk about what the court is deciding, what you should do before the hearing, and what you should do at the hearing. So the court is deciding the answer to this question. Do you, that is the individual who has a guardianship of the person, do you understand the objective of the elective process? That is a tongue twister, and I put it there not to confuse you, but because that is the exact language in the Wisconsin law. Understand the objective of the elective process. What does that mean? The law doesn't have a definition for us, and we understand that to mean, do you know the purpose of an election? Do you know why we have elections? What is decided by an election? And to put that all together, the purpose of an election is to vote for a person so that the person can win. That's a very low standard of cognition, but that is the standard. It's not a civics test. It's not a citizenship test. You don't have to know the ins and outs of the structure of government. Consider how people not alleged to be incompetent make decisions about who to vote for. The law does not require research or fact checking. The law does not ask people why they are voting for a particular candidate. The law does not require any kind of explanation. And so all those things should not be required of an individual under guardianship who wants to get their right to vote back. So the individual needs to explain that they know the purpose of an election. They need to explain that the purpose is to vote for a candidate so the candidate can win. They do not need to say which candidate they want to vote for or why they want to vote for that particular candidate. And again, they can remind the court what I've just said, that other people do not have to pass any tests or explain anything before they vote. So before the hearing, it's important that the individual think about what it means to vote, why they want to vote, what they know about elections, and how they decide who to vote for. And then they should practice. They should practice what they want to tell the court, and ideally in front of a supporter. Practice makes perfect. I think that is a good thing to live by. And as I've already mentioned, finding someone who agrees that you should be allowed to vote is a good idea. It can be anybody. friend, family member, etc. It'd be nice if they would come to the hearing with the individual and also tell the court why the individual should be allowed to vote, or they can write a letter of support expressing their opinion. At the hearing, the individual tells the court why they should be allowed to vote. A simple way is to tell the court that they want to vote so that the person they vote for can win. The person who has come along should explain as well. And if there are any letters of support, those should be provided to the judge. Jen explained to us why she wanted to vote. She wanted to pick the candidate. She wanted to express her opinion about who she wanted to win. She was able to convince the court that she understood the purpose of an election. Now, what the court will actually ask the individual varies from court to court. But if the individual has thought beforehand and practiced beforehand about what they know, they will be able to succeed. So again, the court will listen to the individual, the supporters, and the guardian ad litem. The court will make a decision and put it in an order and the notice of voter eligibility. If, unfortunately, the court decides to deny the petition and not give the individual their right to vote back, you can try again in roughly 6 months. It's actually a number of days. I think it's 180 days, but that translates roughly to 6 months. Now, I've given you a whole lot of information, and remember the 2 resources I mentioned earlier. These contain the information I've talked about. Other resources can be found on the DRW voting resource page, the DRW self-determination and guardianship resource page, the Wisconsin Disability Vote Coalition, and as already mentioned several times, the resource guides. Barbara mentioned the Disability Rights Wisconsin voter hotline, and there's the phone number and email address that's available year-round and can answer a wealth of questions even beyond the guardianship realm. If you have nitty-gritty questions about where do I register, how do I register, what's photo ID, what's proof of residence, you can ask the voter hotline. Another excellent resource is the Wisconsin Guardianship Support Center. And on our panel of excerpts, we have the attorney from the center who will be joining us shortly. And they provide information on issues related to adult guardianship, protective placement, and advanced directives. And there's their phone number, 855-409-9410. And that concludes my presentation on the topic of protecting and preserving the right to vote for people in the guardianship arena. We're now going to turn to your questions, and you can see on your screen the names of our panelists, and they will be introducing themselves shortly, and Barbara will be giving them the questions. So thanks for your attention, and let's have some questions.
Ellen, thank you so much. This is Barbara Beckert again with DRW. Thanks for all the important information you just shared. As Ellen said, we'll be sending out a follow-up email in the near future that everyone will receive with links to the information. So at this point, should we turn it over and have our panelists introduce themselves, or do you want me to start with the questions?
Let's have the panelists introduce themselves.
All right, very good. Mitch, would you like to go first, please?
Sure. Hello, everybody. My name is Mitch Hagopian. I'm the managing attorney for the Disability Rights Wisconsin's Community and Institutions team, and I'm here because I've actually represented one person in getting their right to vote restored.
Thank you, Mitch. Peter, could you introduce yourself, please?
Hi, my name is Peter Navis. Currently, I'm the Judicial Court Commissioner in Walworth County, which means that I hear cases that the judges want me to hear on their behalf. Prior before I was a court commissioner, I did work in the county corporation council offices for 9 years in Dodge County and Walworth County. And I represented those counties and most or almost all the guardianships that came through those two counties. And prior to that, I served as a guardian ad litem in guardianship cases when I was in private practice. So very familiar with these types of issues that individuals under these orders face. Thanks.
Yeah, thanks so much for being a resource today, Peter. Polly, can you introduce yourself?
Sure, I'm Polly Shoemaker. I'm the managing attorney of the Wisconsin Guardianship Support Center. I primarily provide information and resources on issues relating to guardianship and powers of attorney. I'm not able to provide any direct representation, but I'm certainly always happy to answer questions and try to walk people through the process and provide forms as necessary.
Yeah, thank you. And Polly, thanks to you and the Guardianship Support Center for being such a great partner and all the good work you do. So I'm going to ask first some of the questions that were in the chat. So the first question, and the panel members can kind of fight it out as to who will respond. Is there a standardized evaluation court form specific to the capacity to vote that's used by the physician or psychologist? I'm wondering if that might be a Peter question.
Sure, I'll be happy to answer that. So there's not a standard court form or a professional form for doctors or psychologists to use in evaluating the specific question regarding the capacity to vote. There is a portion of the court form for their evaluation for initial guardianships that does include the same kind of box that Ellen was referring to in the petitions, but it does not include any special criteria related to the voting right issue. When I was in corporation counsel, when that was an issue that we know was important to the individual, is that we would make sure that the doctor addressed that issue specifically and was prepared to address that issue for the court if the court had questions about it.
And this is Mitch. In the case we didn't have a doctor's opinion about my client's competency to vote. And one of our arguments was that such a competency determination by a medical professional is unnecessary for this particular question because it's not one that really lends itself to what doctors or psychologists have expertise in. So yeah, there's no form. You can't just, there's no like competency to vote form that can certify you that you understand the objective of the elective process. You're going to have to show that through the means that Ellen talked about in her presentation. But we do think it's important to indicate our feeling that the need for a medical examination or a medical opinion on this question is unnecessary. It's not required by the statute, and it's really kind of inappropriate for this kind of question, and it's expensive and it's time consuming, and it would have the effect of probably preventing some people from trying to pursue this process. So that's how we feel about it.
And this is Polly. I spoke in the chat with Signe, who asked the question briefly, and one of the concerns as well that she had is when it's part of the initial evaluation in an initial guardianship proceeding, whether there's anything that can provide more information to the doctor or psychologist who's doing the eval, because it's not uncommon that they will often simply check boxes without necessarily stopping to consider what it actually means. There hasn't been a whole lot of education on what this question means. And I'm not aware of much in the way of resources that can be provided, but I think this is part of why it's really important that people who want to retain the right to vote, who are going through a guardianship proceeding, and family members and advocates who are working with them, make sure that they talk about it with people as best they can. I told Signe that I would look and see if there are any resources from any of the national groups that work on guardianship and the right to vote to see if there's any educational materials that we can provide to people who do these evaluations regularly that will help them assess this specific question when they're going through that form.
Thank you all for that helpful information. And I just wanted to note that our national organization, the National Disability Rights Network, may potentially be a resource on this. And We think it's a good thing that there aren't restrictive tests for people to pass in voting, and that would be problematic. And so it's been confusing because there have been some voices in Wisconsin that have given the public the impression that there are standardized questions or a test that people have to pass. So thank you to our panelists for setting the record straight. I'm going to ask a few more of the great questions that we're getting in the chat. So here's one. Guardianship papers from years ago don't have the right check boxes. How do we obtain updated paperwork to reflect rights retained?
I'd be happy to answer this one too. This is Peter Navis again. When I was in the corporation counsel offices, it was very common to have orders from the 70s, 80s, early 90s that are very simple orders that basically give all authority to the guardian and everything is removed from the ward. Under the law that existed at that time, that would have included the right to vote without any consideration or thought by the court. So because of that, it is required then to petition to have that right restored, or any other rights that that individual may want to have restored. But if it's the right to vote specifically, it would have to go through this process to modify the scope of the guardianship.
Thank you, Peter. Appreciate that. Next question. One of my clients, I'm a social worker, asked how she could petition to completely reverse her own guardianship and become her own person. Her mom was appointed her guardian after a medical crisis shortly after she turned 18. Now, a decade later, her condition is under control and she's very independent. Does disability rights assist in these cases?
I guess I have to answer that one, right, Barbara?
I think so. You could mention the pro bono.
Yeah, right. Well, it's not that hard to start the process for terminating a guardianship if you believe that it is no longer appropriate for you, and there's a form available on the court website to start that process. It is actually form GN 3650, and it's called the petition for termination of guardianship of the person of the estate. There's another form also if you don't think the guardianship should be completely terminated, but it should be modified and some rights, restored, but not all of them. There's another form for that, and that is GN 3655. And Disability Rights Wisconsin does not typically represent people in those types of actions. If you file a petition and you are indigent, you can request that the court appoint an attorney to represent you in that action. And then if you file that petition to modify or to terminate, that will typically also trigger a new medical or psychological examination. And you have the right to get your own to support your petition. But we do not, that's not part of what we do to represent people in actions to terminate the guardianship. We are trying to set up a pro bono panel here at Disability Rights Wisconsin that would deal specifically with restoring the right to vote for people who lost it in the guardianship process. But that would be limited just to the question of the right to vote, not to everything else that you may have lost in the guardianship. And one of the reasons for that is because Ellen talked about the standard for voting, the understanding the objective of the elective process. That's kind of its own little competency standard. And it doesn't, it's different than the one that applies to all the other stuff that the doctor and the court are looking at when they're deciding whether or not to impose a guardianship. So this standard to, competency to vote is quite a bit lower than the regular standard for capacity. So we think, and it's because we don't believe that it requires a medical examination in support of it. This is something that can be done, relatively quickly. I'll tell you that the case I did from start to finish, the time the client contacted us to when we had the court hearing and got this person's right to vote restored, took about 2 weeks. part of the reason was because we wanted to get this done right before the November election in 2020. But again, because the judge agreed there was no medical report necessary. The guardian ad litem did their job quickly. We were able to get on the court's calendar. The hearing took about half an hour. The judge restored the right to vote. And then the register and probate filed the forms that Ellen was talking about, which alerted the Wisconsin Election Commission that the person was now eligible to register to vote and to vote in the election. So, we're hoping that we can recruit pro bono attorneys to help us with that limited part of the guardianship process.
Thank you, Mitch. And I just want to note that the guide that Ellen has developed will include the forms, and that will be among the resources posted on the website that you will be getting information about. So next question, this should be a quick one. This is from Milwaukee County Regional Ombudsman and the Board on Aging and Long-Term Care. For clarity, am I correct in understanding that an activated healthcare power of attorney agent would not be allowed to limit an individual's ability to vote?
This is Polly, that is correct. A healthcare agent has no authority whatsoever with anything to do with voting. The only way the right to vote can be limited is going through a court.
Yeah, thank you for asking that question, because this is an area where there's often confusion, and Polly, you answered it perfectly. So on to the next one. I do not remember if this was mentioned, but once someone deemed incompetent by a judge, is there a certain time frame they have to wait in order to get their right to vote back? Does waiting longer increase your chances to get your right to vote back? So who'd like to take that one?
I'd be happy to. This is Peter Navis again.
Thank
There's
you.
not a mandatory time limit. And I'll clarify that because, as Ellen pointed out in her presentation, there is a provision in the statutes that talk about waiting 180 days before filing to modify a guardianship order, which would include the voting right issue. However, there's also a provision in there that says the court could hear that issue at any time if there's exigent circumstances. And that simply just means if there's an emergency, something that has to be addressed now rather than later. And if the court finds a good cause to hear it, and new evidence can be a basis for that, or addressing something that maybe wasn't addressed thoroughly at the original order. It was my common experience that at a lot of guardianship hearings, there's not a lot of time spent on addressing each individual right. Usually if most parties are in agreement with everything, then the order is entered and the court may not directly address, in this example, the voting right issue. So if that was the case, and even a week later or a month later, the person says, you know what, I didn't realize I was going to lose my right to vote, or I would like to have that back. And if it was never really addressed, I think that could constitute a reason for the court to hear the case again very, very quickly. As it relates to the passage of time, if it was something that the court had addressed, the court would probably want to know what changed over whatever period of time that indicates that the individual is now able to make those kinds of decisions or understand the elective process. So in that sense, maybe more time would be helpful, but really the issue is the standard itself. And if the person's able to present enough information to the court to demonstrate that they now, at the time of the new hearing, understand the issues, then they're very likely to get their right back.
Yeah, thank you, Peter. That's really helpful. I have one quick question that I think you might be the person to address. We've heard that sometimes court registers and probate don't want to give a copy of the determination in order to the guardian or ward. Can this be refused? And if so, what recourse do people have?
No, it can't be refused. The ward, the individual, and their guardian have an absolute right to the paperwork in their file at all times. All they have to do is ask. They're entitled to it under the law. There are rules about who else has access to the court file, and generally the answer is no one else really has access to the file if they want copies of the orders. There are some exceptions and things like that, but if the ward or the guardian wants a copy of their order, there's no reason to prevent that from happening.
All right, well, thank you so much to our panel members. I'm just going to turn it over to Ellen to say the final thank you and reminder about the resources. And thanks again to our panel members for all their expertise.
Thanks everybody for joining us. I hope you got the information you needed to consider helping people get their right to vote back. Two things that are important to remember. The standard is not very high, and it shouldn't be very high. It's not high for the rest of us. The same standard should be used for everybody. You and I understand how to choose a candidate, and I'm old enough to remember when people voted for John Kennedy because they liked the way he looked. So the standard is not very high, and again, nor should it be, because it's not very high for the rest of us. So remember that. And number two, yes, the process is a legal process, but it's fairly simple compared to other legal processes. And there's plenty of support material in those guidelines and through the 2 hotline numbers that I mentioned to help you access this process. So I really encourage you to think it over and to do it.
All right, thank you, Monica. Thank you to our panel. Thank you, Ellen, and thanks to everyone who attended today. We will be following up with you with voting rights information about guardianship and voting. So stay tuned, and it was great to be together today for such an important voting rights topic. We'll stick around on the Zoom for just a little bit with the speakers in case there are any final questions. I hope that's okay, Ellen. I should have said thank you, Jeannie. If you're still on, Jeannie, you did a great job with all of our tech issues, with avoiding tech issues.
Yes, our production assistant was excellent. She's just fled though.
She what? She left?
She just left.
Yeah. Well, we will follow up. All right, well, sometimes people linger with a question or two, so I thought as long as we had the brain trust here, we didn't want to let
I have
people
a
off.
question. Mitch,
Oh,
what county was your successful case in? I know we talked about it before, but I don't remember.
I don't remember either, Vicky. Somewhere out west. I think it was St. Croix, now that I think about it.
Okay.
Yeah. Mhm. But I'm not
Did
sure.
you also have one in Winnebago?
What's that?
Didn't you also have one in Winnebago, or am I misremembering that?
I don't think so. I had one where I advised a guardian ad litem
And
about
Peter-
something, but I don't remember what county that was in. I
That was
was
Marathon.
in on it. Marathon?
And Peter's still on the call. He's told me that Walworth County had quite a few,
Yeah.
had 8 or so that were all successful.
Right. Yeah, I mean, they were all done as a formal petition to modify, not as a specific petition, like what you have provided, Ellen. But right, they were all done after the fact and were successful. One of the reasons I think we were successful was laying the groundwork with the judges in other hearings to kind of, like at the initial hearings of other cases, kind of reminding them to go through each one of those things, especially the voting rights. So that when we got to the modification ones, they were familiar with those issues. They were rather straightforward then.
So were they modifying though in Walworth without a doctor's report?
Yes.
Okay.
Yeah. The first time we had one, the judge asked why we didn't have one. And I explained because the statute doesn't require it. Kind of like how Mitch had said, the judges are going to kind of presume that they need one because that's what they're used to. But the statute only requires it for the initial guardianship, arguably also for a termination. But for a modification under 5464, it's not required. And again, I agree, it's not a competency issue, which is where you need the evaluation. It's a capacity issue, which is a fact-dependent issue. So, I mean, I don't even think Now, there was one time we had testimony on the issue, but otherwise it was just offers of proof.
Michelle, I just wanted to mention, I know your time is up, so we understand you need to sign off and get to your next job. You're a hot commodity. Interpreters are so important. Thank you for being here today and doing this all yourself.
If there are attorneys still on the call, there is going to be a CLE in October that will do a deep dive for attorneys. Non-attorneys can sign up for it too, although it does cost money. But it's the nitty-gritty of form numbers and statutory citations. So attorneys will find that beneficial. I'm also will be publishing in the newsletter of the elder law section and elder law and special needs section of the State Bar, a walkthrough of the restoration process. And it includes an analysis of whether the examining doctor or psychologist is needed. And there's statutory construction that you can walk through to convince the judge that you don't need those people to weigh in.
Well, I know I've learned a lot today with the Q&A and everything, so this has been really helpful. And Polly and Mitch and Peter, thanks a lot for sharing your expertise. I think we have a lot of continuing education to do. This is an area where there's a lot of misunderstanding about rights. So I hope we can continue to work together in this. And Vicki would love to, you know, partner with you as well. It's always great to
Sign me
see
up.
you.
And I think
Yeah.
in addition to Vicky, I think we got Stephen Wheeler is already.
Yeah.
volunteered. So we're off and running. Now we need.
We're off and running. Yeah.
We want their right restored.
Yeah.
Yes,
Yeah.
exactly.
Great.
So
Great.
that's exciting. All right. Well,
Okay.
thanks again, everyone. We will formally bring things to an end and end the Zoom.
Thanks a lot. Good to see you, Peter.
Thanks.
Great
too,
work,
Mitch.
Ellen.
Thank you,
Yeah, good job,
everybody.
Ellen. Thanks, Polly.